Welcome to the Diary of a Ghanaian Lawyer. Over here, we demystify the law, one episode at a time. I'm your host, Lawyer Fredericka, and today we are stepping into the lawyer's office, the courtroom, and your room. Yes, a quick shout out to our producer, Supreme Studios. Now they are responsible for our perfect audio editing, our video editing, website creation, and then our social media management. You can check them out on their website, supremestudios.online, supremestudios.online, supremestudios.online. Trust me, you won't regret it when you patronize them. So, following our episode on how to cross-examine like a pro, several listeners reached out to us asking questions like, how do I handle cross-examination without falling apart? You only said something for the lawyers on how they can cross-examine like a pro. What about us, the ordinary people? Now, this episode is dedicated to all those who reached out, especially to our dear listener who has a trial coming up this September. We see you, we hear you, and we hope this episode energizes you for the trial ahead. Now, this episode will be in two folds. One for the lawyer on how to prepare your client or your witness for trial, specifically for examination in chief and cross-examination. Then the second one or the other one will be for you, the witness, on how to carry yourself and survive the heat of trial. Now, whether you're a lawyer, a soon-to-be witness, or just a curious listener, you will walk away today with an inside scoop on how to stand in court with confidence and not crumble under pressure. So grab your notepad and let's dive in. Yes, so we would begin with the basics. Now, if you've listened to our episode on how to cross-examine like a pro, you already know the drill. But in case you missed it, go check it out after this one. It's available on Spotify, Podbean, Castbox, YouTube, TikTok, Facebook, and Instagram. But we would have a refresher from that episode over here. There are basically two things happening during trial: examination in chief and cross-examination. Examination in chief is when a witness gives their story. This is a very cool and friendly zone. Then cross-examination is when the opposing side or the opposing lawyer tries to poke holes in that story. Now that is the battle zone. A lot of people think they can walk into court and simply tell the judge what happened, but it is not that simple. In reality, a poorly prepared witness can ruin an otherwise solid and good case. Let me tell you a quick story. I once worked on a rent case involving a client I'll call Kofi. He had receipts, photos, everything. But on the stand, Kofi froze. He said things like, I think I paid the rent in May or June. Meanwhile, the receipts he tendered clearly said March. It gave the opposing counsel a field day, and he hammered on it so much because the inconsistencies were a lot. So he hammered on the inconsistencies to poke more holes into Kofi's story. Now, when Kofi realized this, it broke his confidence and he kept fumbling over and over. This is why preparation is everything. Now, one thing I didn't know then in Kofi's case as a young lawyer, and something I think the judge could have drawn our attention to, is that the witness has a right to ask for leave or permission to refer to his or her witness statement to refresh his memory. This is most ideal when several figures and dates are involved. Of course, you can't just be reading every answer from your filed witness statement, but you can refer to it when a date or amount doesn't readily come to mind. Now, how do you ensure you don't become like Kofi or have a client like Kofi? We would start with the lawyers. As a lawyer, if you get a client or a witness that you have to prepare, this is what you have to do. Before 2014, that is before the coming into force of the High Court Civil Procedure Amendment Rules 2014, CI 87, Lawyers had to lead witnesses through their evidence in chief in open court by asking what we call non-leading questions. Now, CI 87 changed the game. Because of CI 47, witnesses can now file their full story in writing with all the documents that they seek to rely on ahead of time, so that examination in chief that used to take hours in court because you had to narrate everything right in court now takes just some few minutes for it to be done because of CI 87. Now, some judges, however, still prefer the oral evidence in chief, especially in criminal or district court cases. As a lawyer, if you have to ask your witness to produce his evidence in chief in court orally, do your best to ask non-leading questions. I repeat, if you find yourself in that situation, remember the golden rule. Ask non-leading questions. You might ask, what are non-leading questions? They are basically questions, or usually questions that begin with what, why, how. Such questions prompt a response that is not a yes or no, but it rather invites the witness to tell their story, what exactly happened, through their own mouth and not their lawyers. So if the answer to your question is likely to be yes or no, don't ask it when doing examination in chief. For instance, instead of asking, your name is Kwame Mensah and you're an architect, right? Say, what is your name? Then later you follow up with, what do you do for a living? Now, instead of asking, you found the house on the internet, didn't you? Say, how did you find or come by your current house? Now, instead of asking, the landlord told you to leave even though you hadn't broken any rules, isn't that what happened? Say, tell this court the circumstances leading up to your eviction. Now, these are examples that should give you a fair idea of what non-leading questions are. Remember, employ the use of question words like what, why, where, and how when conducting examination in chief. Now, the above information is for when examination in chief has to be done orally. If a witness is given their evidence and it has to be written down first as witness statements for it to be adopted in court as evidence in chief, this is what you can do as a lawyer. So I prepared this perfect checklist. You can add on to it, but please go through it. So part 1 is capture the story of your witness. Sit down with your witness. Let them narrate their story in their own words. If the witness is not available physically, you can arrange for a recorded video call, exchange emails, WhatsApp message, and voice notes. Something to ensure there's evidence you got their story through them and not that you concocted your own story as a lawyer. This is very important. Now listen attentively for gaps, contradictions, dates, names, and key events from their story. Never coach a witness to lie or exaggerate. Courts hate rehearsed testimony, and they would find out. Check the consistency of their story with the pleadings, affidavits, or earlier statements they've made in that case or any other related case. A diligent lawyer can use all these things against your witness if they find out they are contradicting themselves. Also, you have to avoid the rule of departure trap. That is where a party suddenly introduces new facts in their witness statements that were not in their pleadings. In other words, if a party in a case says things in his witness statements which were not previously captured in their writ or statement of defense, the court can strike it out as that falls under the rule of departure in law. As a lawyer, when you are drafting the witness statement, help the witness to create a timeline or a story map. How do you do this? You help the witness organize their story in a logical way. You can ask questions like, what happened first? Then what happened afterwards? Okay, what proof do you have for this thing that you just said? And this leads to a very important point. Remove rumors or speculation from your witness statement. Make sure not to reproduce rumors or speculative claims in the witness statement. For instance, just because your client said somebody bribed a court official or a judge does not mean reproduce it in the witness statements, especially when your client was not an eyewitness to it or is saying it based on rumors or speculations. This can be very detrimental to your case. Part 2, from after listening to your client narrate a story, the evidence available. This is optional. I mean, if you have documents to attach, if you have videos, pictures to attach, this is also another checklist that you have to check. Now, after the witness has narrated their story and you, the lawyer, you've couched it beautifully, it's time to attach the documents. Make sure every document you attach has a reference made in the witness statement. For instance, paragraph 1 or 2 can say, I am Kofi. I bought this land from a queer and an indenture was prepared in my favor. Full stop. Then you say, attached and marked as Exhibit A is a copy of the indenture. So that's the reference to the attachment you are going to attach to your witness statement to prove that narration that you just made. As a lawyer, it is your duty to ensure that the right documents are attended. Make sure each document, audio recording, video recording, or photographs comply with the law. Make sure those that require stamping are stamped. Make sure the originals are available, or in the absence, certified true copies and the like are all available. Most importantly, make sure your witness knows the content of the documents they have attached to their witness statement. Now we move on to the filing stage. Now that you've written down the witness statement and attached the labeled documents to be relied on, you make arrangements for it to be filed in court and make sure the other side is also served. Before the D-Day comes, the day for the trial comes, take the witness through their pleadings and witness statements. And, it's a bit embarrassing when the witness doesn't even know what he has attached to his own witness statement. I personally normally insist my witnesses make copies of their witness statements and peruse thoroughly before they testify in court, because sometimes they can get forgetful. Now, we are done with the paperwork. Let's move on to how to conduct examination in chief when a witness files a witness statement. So after the court pleasantries, the lawyer announces that the witness is available to testify. The judge will then direct that the witness be put in the box. The witness is led by the court clerk to swear or affirm to speak the truth only in that matter. Now, the clerk clears the courtroom of all other witnesses who are likely to testify in that case. This is to ensure that, they are not compromised by what the other witness is saying. What happens after this is a matter of style and direction from the judge trying the matter. Now, a witness statement ordinarily has the full name, the residential address, and occupation of the witness. Some judges expect the lawyer to still expressly ask questions like, mention your full name to the hearing of this court, where do you live, what work do you do? Others, however, ask that you skip it and just go straight to business, like, on the first day of January 2011, you caused the witness statement to be filed on your behalf in respect of this matter. Kindly confirm the said witness statement and your signature thereon. The witness then looks at the witness statement and confirms if that's his witness statement and his signature on it. The lawyer then asks, what do you seek to do with the said witness statement? Then the witness will answer, I want to rely on it as my testimony in chief. Mostly when witnesses are asked, what do you seek to do with the said witness statement, they are confused as to what to say. Some judges allow you, the lawyer, to ask leading questions like, do you seek to rely on it as your witness statement? So the witness can say yes. This is the only time a leading question is allowed in examination in chief of one's witness. Now, after the witness has tendered or agreed that he wants to rely on the witness statements that he has filed and its attachments, the lawyer will then pray to the judge to adopt the witness statement as evidence in chief. If the opposing lawyer does not object to the witness statement, then the witness statement is adopted by the judge. And hooray, you are done with part 1. Now, if you have documents attached to your witness statement, your lawyer would seek to tender it one after the other. If no objections are raised, the documents are adopted. If objections are raised and sustained, the documents do not make it as part of your evidence. As a witness, you can opt to sit or stand when being cross-examined. Now, once the examination in chief is done, Brace yourself for cross-examination. This is where I come to you, the witnesses. Now, dear witness, stay calm. I know it's not easy speaking in the presence of several people. I know it can be intimidating, but the judge and the opposing lawyer, sometimes they may not be too friendly, but remember to stay calm. You don't have to look at everybody in the room unless you are those witnesses that thinks you're addressing everyone in the courtroom. No, you're actually addressing only the judge. So to help you stay calm, you can just focus on the judge and keep taking cues from the judge. Now, stick to the truth. I can't emphasize this enough. You are allowed to say you don't know or can't remember, but don't lie. Those that you would like to refer to your witness statements to jog your memory, you can ask the judge for permission to do so. As I said earlier, it's not every information you would be allowed to refer to in your witness statement, so prepare thoroughly before coming to testify. And remember that the more you say I don't know or I can't remember as an answer during cross-examination, the more your case will be affected. So go prepared. Remember to dress decently. Don't wear slippers, don't wear shorts, don't wear hats, don't wear sleeveless tops and the likes to court. I'm not saying wear a suit, although a suit would be nice, but at least look decent and official. Be truthful. Be prepared. Stay calm. Don't panic. Focus on the judge. I mean, that's optional. Some judges can be in a bad mood or something, but just focus on something in the courtroom that keeps you calm. Pace yourself. Now, in Ghana, the judge is either writing or the court recorder is typing. So learn to speak at a dictational pace so everything you say is captured on record. Don't get too personal. Remember that cross-examination is not personal. The other lawyer may raise their voice or ask annoying questions, but stay calm and stick to answering politely. They are just doing their jobs. They don't know you from anywhere. Now, don't be evasive. Stick to answering questions asked and don't formulate your own answers and answer them. The judge might get the impression you are hiding something when you are an evasive witness. Also, do not question the lawyer cross-examining you. Your duty there is to answer, not question. Don't ask questions like, were you there? Who told you? And the like. No, that's not done during cross-examination. Don't argue with the counsel cross-examining you whilst you're in the box. Keep your answers brief and straight to the point. The more information you volunteer, the more you open yourself up. Of course, this does not apply to all instances, but do remember that. Now, learn to put your ego aside. Don't let your emotions ruin the case for everybody. If you're a witness but not a party to the case, remember that you are there to corroborate a case or help the main party. Don't make it about you. Know the aim of your testimony and stick to proving that. Now, be smart, but don't be overly smart. Trying to understand why the lawyer is asking a particular question can confuse you and throw you off balance. Just breathe and answer only what is asked of you. Now, know your flaws or the weak points in your case and don't waste time denying them. Being honest makes you more credible, in my opinion. Lastly, be ready for everything and remember to breathe. Pause and answer only what is asked of you. Now, some quick tips. Cross-examination isn't a boxing match, in my opinion. It's chess. That's if you play chess. Learn to stay calm, stay truthful, and you will protect your credibility. And ordinarily, cross-examination, as I indicated, is not only for the witness. The lawyer is also under an obligation to object to some questions. And we would address that in another episode. And we would also work on getting the episode where documents, the special requirements of documents that you attach to your witness statements. So do stay tuned. Now, this will be all for your crash course on preparing for trial, from the friendly zone of evidence in chief to the heat of the cross-examination. If you're a lawyer, take the time to walk your witness through the processes I've stated above. If you're a witness, remember, preparation isn't about memorizing answers. It's about knowing your story and being truthful with the court. If you found this episode helpful, Share it with someone heading to court soon. And if you've got a courtroom survival story, you know I want to hear it. Send me a DM or a voice note. I might just feature it in our next podcast. Until next time, stay ready, stay credible, and stay calm in court. Bye.